Welcome to the Debrief, everybody. We have a lot to talk about tonight. Let's start with the last-minute plea deal that came late yesterday in the case of former NFL player Kellen Winslow II. As we reported here yesterday, Winslow cut a deal with prosecutors minutes before opening statements were scheduled.
How do you plead to that? Guilty or not guilty?
Guilty.
I'm sorry?
Guilty.
5 accusers, 2 separate trials, 3 convictions, 2 guilty pleas. That is how the case of Kellen Winslow II concluded. The deal will put the former NFL player behind bars for 12 to 18 years, and it spared him the chance he'd be convicted and face a possible life sentence. But as the judge accepted the plea, hesitation.
Now, I know we've had a long lunch hour and you spent the last, about 2.5 hours talking to your attorneys. Is that correct?
Yes.
Has that been enough time for you to make an informed decision about your decision today? Because the option is to go to trial. We have jurors out there waiting to start with opening statements in about 10 minutes.
The judge asked again, then another pause.
Have you had enough time to thoroughly discuss this with your attorneys?
Yes, Your Honor.
Okay. Well, I noticed you looked into the audience, so I'm asking you. I'm not asking anybody else because, sir, this is your decision and your decision alone. I think you understand that. Have you had enough time to discuss this?
Yes.
Okay.
The judge gave Winslow time to meet with his attorneys. Then, while pleading guilty, the defendant begged for leniency.
It would be no less than 12 years and no more than 18 years. Is that your understanding of the plea agreement?
Yes, Your Honor, and I pray to God that you give me 12 and I can go home to my family as soon as possible, Your Honor.
Understand, and I will hear argument that your attorneys will make that would attempt to convince the court that 12 years is appropriate.
Finally, Winslow accepted. The judge dismissed the jury with the words that a trial was no longer necessary in this case.
Ultimately, prosecutors scored 1 win for each of the 5 accusers. Here's the scorecard out of the 8 original charges. As to Jane Doe number 1, Winslow pleaded guilty to sexual battery against a 54-year-old hitchhiker. As to Jane Doe number 2, a jury over the summer convicted Winslow of forcible rape against a 59-year-old homeless woman. As to Doe number 3, a jury convicted Winslow of indecent exposure against a woman gardening outside her home. Doe number 4, a guilty plea to raping an unconscious teen in 2003. Doe number 5, a jury convicted Winslow over the summer of lewd conduct against a 77-year-old woman at a health club. An attorney who authored the book Judging Winslow Jr. spoke with Law&Crime earlier today. She was in the courtroom and described when Judge Bowman announced that plea deal.
Well, I think everybody in that courtroom was completely shocked. I mean, I was sitting in there, I was with all the media, and everybody just was so stunned. We had been sent out for 2 hours, we came back, now we're ready for these opening statements, and then all of a sudden Judge Bowman says that Kellen Winslow wants to plead guilty, and I think that everybody just practically fell off their chair. It was very, very shocking. So I think that in this case, it's really a good thing that the women don't have to come and testify. Jane Doe number 4, of course, the woman from the rape from 15 years ago, she cried a lot on the stand when she was trying to recount some of the stuff. She would take that Kleenex, put it over her eyes. She was in absolute agony. There's no other way to describe that. Every one of those women had incredible distress, and it was so apparent as they walked through that back door and took that witness stand.
We now know the legal conclusion of the case. Here is how it happened as the day unfolded yesterday. Earlier yesterday, Winslow's attorneys fought to introduce evidence that one of the accusers had sex with her boyfriend and that he was the source of DNA revealed by a rape kit, not the defendant. This gets into a critical area of evidence law, which governs the use of evidence involving a purported victim of a sex crime.
The victim's own admission, she had sexual encounter with an individual whose DNA was actually on her person. which was a consensual act. However, the injuries in this particular case were redness in the vaginal area and redness in the anal area, and they're non-conclusive. In other words, there's just redness. They can't tell what they mean, where they came from. The defense sought to introduce this testimony because the case law specifically has made allowances for this type of testimony when there's a possibility it's an alternative explanation for the injury. There is DNA of an individual, Bobby Guzman, who is her boyfriend. Mr. Winslow's DNA is not. In other words, she claims that she was vaginally raped and potentially sodomized by Mr. Winslow, and there's no DNA. The only DNA that Jane Doe 2 has on her person is that of Bobby Guzman, who apparently somewhere in the area between 1 to 4 days she had a sexual encounter with.
Prosecutors admit that Jane Doe number 2 did have sex with her boyfriend 3 days before she was examined by a nurse after she reported she was assaulted. But the state says the conduct was consensual sex and different from what Jane Doe number 2 alleges Winslow did to her.
Specifically stated that that was penile vaginal intercourse and that other consensual partner's DNA was collected from her vaginal area, as well as there was a very, very low level of inclusion along her fingernail scrapings of that same consensual partner. Last trial, the defense attempted to get into that area of cross-examination with Jane Doe 2, and the court, I think, rightly precluded them from doing so because that's exactly what Evidence Code sections 782 and 1103 are designed to prevent. The possible spillover impacting the credibility of a sexual assault victim just by virtue of the fact that they've had consensual sex with a partner shortly in time prior to the reported sexual assault. Jane Doe 2 never reported and has never said that she engaged in any consensual penile anal intercourse with her consensual partner. Therefore, Mr. Carlos's offer of proof as to its relevance, I think, is lacking and should not overcome the presumption that any consensual sexual activity should be barred.
Basically refused to allow any of this evidence of another sex act into this trial. Basically, the judge's ruling from the original trial stood. Here is the explanation.
The court will stand by its previous ruling in the earlier trial. The evidence of the consensual sexual intercourse that she had with her boyfriend will be excluded pursuant to Evidence Code Section 782 and 1103. Especially at this point in time, given the fact that the forcible rape charge involving Jane Doe number 2 has been resolved, any redness in her vaginal area that may have been caused by consensual sex with her boyfriend is not relevant because the only charge left with respect to Jane 2 is the act of forcible sodomy. So any redness in the vaginal area that may have been caused by the consensual sex with her boyfriend is not relevant, and what marginal relevance it might have is certainly does not survive a 352 analysis. There's almost no probative value whatsoever to that evidence, so it will be excluded.
With us tonight here on the Debrief, Linda Kenney, Baden, and Bernarda, Villalona. So, Linda,
yes.
This is basically California's version of a rape shield law. This seemed like a good ruling from the judge from where I sit. You can't just point to other sex acts with other people and say that that affects a trial where you're accusing a defendant of something unwanted.
Right. Well, that's what the rape shield law is supposed to protect the victim here. The problem, the defense was saying, hey, this should have really been also in the first trial because the redness that the sane nurse was referring to could be from consensual sex that she had with a boyfriend. And how do we get around the rape shield law if we can't point to the fact that the redness can come from other areas?
So do you disagree that this was a good ruling?
I think the ruling was right in this particular case because the judge is correct that all we had left was the sodomy. But in the first case, if the defense had brought it in, perhaps that ruling should have been allowed.
Bernarda, we had a lot of hesitation on behalf of the defendant asking for leniency during that plea colloquy. What was going on there?
Well, I think, first off, I have a problem with the plea because during the entire plea, it seems that Winslow, he was very hesitant in answering the questions. He was hesitant in actually admitting to his guilt. He took very long pauses, which goes to show you that maybe this plea is not knowingly or voluntarily or intelligently being made. And that last plea, for him to get a lesser sentence, the low range, almost goes to show like this is why he's entering into a plea, because I want you to give me the less sentence.
Well, that's what it seemed like. It seemed like he didn't want to admit guilt, but he just wanted to get off the hook as easily as possible. Is that what was going on?
Yes, that's how I interpreted it.
Okay, so is this going to be one of these things, Linda, where he turns around in a couple of days, weeks, months, years, and say, I never really did any of it. I just had to say that because that's what I had to do to get off the hook.
It's going to go for years because he said, I am not thinking clearly. The defense raised the issue of CTE. Counsel in the future is going to say this was an improper plea.
Linda Kenney Baden, who represented NFL player Aaron Hernandez, will point that out as well. R&B singer R. Kelly hiring a new attorney and is possibly adopting a new strategy in his case. Jeff Steinbeck, a Chicago defense attorney known for cutting deals with the feds, is joining the singer's team. Attorney Steve Greenberg, who has represented Kelly all along, is saying that Steinbeck is joining the team so that the attorneys can properly advise R. Kelly of all of his legal options. Greenberg is not saying whether the defense is actually cutting a deal. R. Kelly, of course, facing state and federal sex crimes charges in 3 different states. Prosecutors say the singer held underage women against their will, among other things. A jury has been seated in the retrial of a man accused of murdering a mother and her 3 children. Is $20,000 in unpaid child support the motive, or is there a darker motive involving the victim and a drug cartel? Prosecutors say Henry Segura is the one who, in 2010, killed his girlfriend, Brandy Peters, their 3-year-old child, and Peters' twin 6-year-old daughters. Segura reportedly owed Peters child support and was cheating on his wife with her. Segura, however, says he's innocent. He says Peters was running a cocaine ring for a Mexican drug cartel and skimmed nearly $100 grand out of the cartel's money. The defense says the cartel ordered a hit on Peters and her children. A jury was deadlocked in Segura's first trial after 19 hours of deliberations. And still ahead tonight here on The Debrief, celebrities jumping to the aid of an inmate scheduled for execution in about 2 weeks. Plus, accusations of hidden evidence in a New Hampshire murder trial. You have to hear how the judge and the families of the victims responded. We're back in a moment with those cases and more right here. Celebrities such as Kim Kardashian, Rihanna, and Meek Mill are urging the governor of Texas to stop the execution of death row prisoner Rodney Reed, scheduled to die in 15 days. Reed was convicted in 1996 of murdering Stacey Stites. Reed's attorney spoke to Law&Crime today about new evidence and another suspect in the case.
So the state's case was based on 3 experts who said that Rodney Reed's DNA collected from Ms. Stites' body was evidence of a contemporaneous sexual assault and murder. And that was their case, open and shut. Every witness, all 3 of them, have recanted that testimony. Stacey Stites was strangled with a belt, and half of that belt was found by the side of the road, half of that belt was found by the truck. Today we could test that belt, and it has the capacity to identify the real killer. We've been asking for that in state and federal court, and the prosecutors who are trying to execute Rodney Reed have refused. Jimmy Finnell was a local police officer engaged to Stacey Stites. He was the prime suspect throughout much of the investigation. It is scientifically impossible for Rodney to have done this, and everything points to Jimmy Finnell. And certainly we think any normal person who looks at this, whether they are Kim Kardashian, Dr. Phil, or the guy next door, they're going to be appalled that anyone would think of executing a man based on this evidence.
Sounds a lot like the McStay family murder case. Testimony in another case places a Colorado man at the scene where his fiancée was killed last year. Patrick Frazee is accused of beating Kelsey Berreth to death with a baseball bat. Authorities say Frazee then asked Crystal Lee Kenney to clean up the aftermath. Kenney said she was in a side relationship with Frazee. We have surveillance footage here released by police which shows Berreth at the grocery store shopping with her baby around Thanksgiving of last year. 7 women and 5 men are on this jury. 4 others are alternates. Cameras, live tweeting, and even a sketch artist are banned from the courtroom. So let's jump in with a full panel here. A lot to discuss. Linda Kenney, Baden, no relation whatsoever here. Prosecutors during opening statements said that the defendant was a cold, calculating manipulator. The accusation is that he asked his fiancée, Kelsey Berreth, to put on a blindfold for a candle smell test. And then that's when he hit her with a baseball bat. Previously, he came up with the idea to poison her and also hit her with a pipe. And apparently, according to Crystal Kenney, again, no relation to
right.
Linda Kenney Baden, the baseball bat was it.
And where are they getting this from? From Crystal Lee Kenney, right? She has to be the one to say, this is how it was planned. I either was there or he told me, and the jury is going to have to believe her to convict for the killing of Kelsey Berreth. I think they will, but that's a lot to go on.
Yeah, I mean, Crystal Kenney faces up to 3 years under her deal with prosecutors, Bernarda. So, you know, she's helping clean up the murder scene. And there was all this wrangling going up before trial. Defense didn't file paperwork reportedly to name her as the killer. And apparently during opening statements, they actually just did anyway and said she's the one who did it. So there's all this procedural stuff going on. And I just look and say, well, procedural stuff is one thing. You know, somebody's entitled to a fair defense. If he wants to point the finger at her, then let him do so.
Yeah, I mean, it's normal. I don't see why a judge wouldn't have allowed the defense to actually bring her up as a potential killer, because as long as the defense attorney has some kind of reasonable basis to name her as a killer, then there's nothing unethical of him mentioning her as a killer, because in the end, it's like you have to give the best defense possible for your client.
After the family testified, Linda, we went into surveillance footage. Authorities have Frazee coming and going 11 times at the scene, and he previously told police he'd only been there once on that day. Is that damaging enough?
Yes, absolutely. Without his wife, he was there, and she's never seen again by anybody. Absolutely. And by the way, Kenney has to testify in this case. So whether you name her before, you name her after, who cares?
Absolutely, absolutely. And that will be the key witness we will all be watching and waiting for. A sentencing hearing scheduled for earlier this week has been pushed back to tomorrow in the case of a young Tennessee man who pleaded guilty to killing an older man who he said had sexually abused his girlfriend. Court documents say 25-year-old Sean Foley faced a 3 to 6 year sentencing range for shooting and killing 44-year-old Jimmy Shelton. Foley recorded himself as he confronted Shelton during a sexual incident with a girlfriend. Foley said Shelton attacked him during that recording, so he fired in self-defense. Here is that recording.
All that's on recording is recording right now. I swear to God, you sick. You with her again, and I will drop you. No, that's watch your stop. That's too much. No, that's too much. Come over here. Come here. Come here now. He was molesting her. I have it all on recording. Did you shoot him? Yes, he was molesting her.
A defendant was acquitted of the top charge. The jury was deadlocked as to the second charge. He pleaded to a much lesser charge. A Florida defendant convicted of killing a doctor in her home is asking for a new trial. A colleague found the body of Dr. Teresa Sievers in her home in 2015 when she did not show up to work. Authorities came to suspect her husband, who helped manage her medical practice. The husband, Mark Sievers, a friend, Curtis Wright, and his friend, Jimmy Rogers, were all accused. Wright turned state's witness, and a jury recently convicted Rogers. But the defense for Jimmy Rogers claims prosecutors failed to tell them that the colleague who found the victim's body also heard the husband, Mark Sievers, fighting with the victim about the husband committing Medicare fraud while managing the practice. The defense claims that argument between the husband and the victim wife could have painted the husband as the primary attacker, despite Wright's testimony against Rogers. The Rogers defense now wants a new trial in that case. Let's talk about a similar issue which shut down a double murder trial recently in New Hampshire. Timothy Verrill there is accused of murdering Jenna Pellegrini and Christine Sullivan. At one point, investigators wondered if Amazon's Alexa may have held evidence in the case. After the trial began, Verril's defense discovered not one, but two instances where state police failed to turn over evidence. The judge shut down the proceeding, declared a mistrial, and sent the jurors home. According to the Manchester, New Hampshire union leader, the judge told the jury that human error, mismanagement of files, and negligence by the lead state police investigator led to both the Attorney General and the Public Defender's Office not receiving evidence in a timely manner. The judge told the jury that. The state police released an apology promising to address deficiencies. We are accountable to the people of our state to ensure that our work meets the highest standards of law enforcement integrity and professionalism. When we fall short, we need to acknowledge it and take steps to correct it. That is part of the statement that the state police gave to the Manchester union leaders. So let's jump in here and have a little discussion. At issue were exculpatory emails, the name of a possible alternate suspect, and motive for that alternate suspect, drug money. There was even an undisclosed polygraph. So Bernarda, Linda, what do you make of the judge's statement to the jury? What do you make of the state police apology?
It's sad. It's really sad. It's not only is it sad, it's just reckless. It's definitely reckless. Like, I can't believe that the state police did not turn over any of this information. You know you have to turn this over. How is it that it's not turned over or it's not mentioned to the prosecution? But one thing that you can tell is that the judge believed that the prosecution did not have that information, because had he believed that the prosecution had that information, he could have dismissed that case with prosecutorial from prosecutorial misconduct.
Yes, exactly. Now, I have to also give my disclosure here. I worked in many of these offices when I was up there, and probably know some people tangentially. I've never confirmed it, but I just suspect that I know a few people tangentially who may have been involved in this case. But you got to remember, Linda, New Hampshire, strong defendant morality state, live free or die, hold big government accountable, hold big government at bay, and that plays out in these criminal trials. How many cases do we sit here and watch, Linda, where there's accusations like the Seavers case in Florida where, oh, now there's this information coming out? Was the judge right to just draw the line and say, forget it, we're not going any further until the state gets its ducks in order?
Finally, because that's what needs to be done to get everyone to say, turn over the evidence. We see it all over the case, Aaron, right? In states and federal prosecution, we see claims of habeas that you didn't turn it over. You just turn it over. And the police can't view the prosecutor as their enemy either. The prosecution has to get it. It has to be turned over.
Exactly. Open file discovery in New Hampshire. I've talked about it before. This is an example of how those cases roll out in that state. Thanks a lot, Bernarda and Linda. We will be back tomorrow here on The Debrief at 5 o'clock with our recap of the day in court. We'll see you then.